All right. So with this review, we're pulling it all together for legal environment. So hang on and let's go ahead and launch into the review. So for the final exam, just a couple of reminders that please bring a number 2 pencil, and you're going to have to bubble in your L number as well as your test number. There will be instructions on the test booklet. The exam is cumulative. A lot of material. I'm going to run through it very quickly in this review. There are 100 objective questions. Make sure you understand everything that I'm talking about on this review, because I guarantee it'll be on the final exam. So with that, without further delay, let's go ahead and get started with a final review of a legal environment. Introduction to law. Remember, our system of laws is based on the English common law, and case law becomes precedent to be followed later on. And this is known as the doctrine of stare decisis, or to stand by the decision. Remember, in our hierarchy of laws, the Constitution is at the very top. And so that if there's a conflict between the Constitution and, let's say, a state law, the Constitution governs. You may bring a case in federal court. Sometimes you may bring a case in state court or federal court. But to be in federal court, this is what you must have. The case must either involve a federal law, the U.S. Constitution, a U.S. treaty, or the U.S. must be a party, or the case must be between citizens of different states with at least $75,000 in controversy. We call this last bullet diversity of citizenship. Contracts. You learn 2 sets of contract rules. Common law contract rules govern contracts for land, services, and insurance. Then you learn the rules governing the sale of goods under Article 2 of the Uniform Commercial Code. Remember that a bilateral contract is where a promise is exchanged for another promise. And a unilateral contract, a good example of a unilateral contract was a reward case. And so a unilateral contract is formed when the person has to perform an act to accept the offer. So a reward case, I've lost my dog Nala, and I offer a $200 reward for anyone who finds Nala. How do you accept my offer? Well, you find my dog, right? It's a unilateral offer. An invitation to negotiate is not an offer at all. So an ad in a newspaper or sales circular is not an offer. If the ad, and this makes sense because an ad could have an error in it, right? Or no seller is deemed to have an unlimited supply of goods either. Consideration. So the 3 basic elements of a contract were offer, acceptance, and consideration. Consideration is the price paid for a promise. So as a general rule, when there's no consideration, then the promise or agreement is not binding. So don't be tricked into choosing the answer, it's not ethical. No, it's not binding unless you have consideration. Remember, the promise to perform an existing contract is not consideration. The example we went over in class was involved you were going to build a cabin for me and you demanded a bonus. Forbearance is giving up the right to do something. That could be consideration. So what if I promise my 18-year-old son $10,000 if he doesn't drink alcohol until he's 21 years old? Has he given up a right to do something? No, right? Because the law says that he's not to drink alcohol until he's 21. So if he doesn't drink until he's 21, can he make me give him the $10,000? And the answer is no. So some enforceable obligations do not have to be supported by consideration to be binding. So formal contracts, so in Virginia, that's a contract under seal or a negotiable instrument or a contract recorded in court. That doesn't have to be supported by consideration to be enforceable. Charitable contributions are also enforced for public policy reasons, not because they're supported by consideration. Minors are said to lack capacity to contract. And so there are certain contracts, though, that we make minors honor. So a minor may be held liable for a contract for necessaries. That's food, clothing, and shelter. So ordinarily, we let minors avoid any contract, major in their minority, and for a reasonable time after turning 18, but they're absolutely liable for contracts for necessaries. And by state statute, in a majority of jurisdictions, a minor may also be held liable for the following contracts. Contracts for medical care, education loans, and contracts made while running a business. The statute of frauds does not say that all contracts have to be in writing. Only certain contracts have to be in writing and signed by the party against whom enforcement is sought. So here are the big ones. Real property contracts have to be in writing. Contracts that can't be completed within a year must be in writing. Promises in consideration of marriage, in other words, prenups, have to be in writing. Promise to pay debts of another person must be in writing. And don't forget, Article 2, contracts for the sale of goods costing $500 or more must be in writing to be enforceable. Some defenses and some other contract concepts you need to be aware of. So duress is a wrongful threat, and it creates a voidable agreement. Remember, though, if there is extreme duress, if I hold a gun to your head and I say, sign this contract or I'll shoot, then the contract is void. But ordinary duress creates a voidable agreement. Undue influence only occurs if there's been a fiduciary relationship, one where you are allowed to place great trust in someone else. And with illegality, the courts will not aid any parties to an illegal contract. It leaves the parties right where it finds them. Promissory estoppel is another concept where courts find that there is an obligation. So promissory estoppel is a promise that is not supported by consideration, may still be enforced if the promisor has reason to foresee detrimental reliance on the part of the promisee. The promisee does, in fact, rely on the promise and would sustain a detriment if the promise were not enforced. This was the example we went over in class where Bob Cochran, the accounting professor, promised to give Mary, the music major, $10,000 if she would come down to the College of Business and take all the required accounting courses and pass the CPA exam on the first time around. Mary had no interest in accounting, but she agreed. So she came down and she took all of the accounting courses at Longwood. Miracle of miracles, she passed the CPA exam on the first try. She went to Dr. Cochran and said, all right, give me my $10,000. Does he owe it to her? And the answer is yes. This is an example of promissory estoppel. She relied to the promise. She relied on his promise to her detriment. What's her detriment, you say? Now she's a CPA. Well, she doesn't want to be a CPA. She wants to be a musician. And so she had to take all of her time to take the classes down here. She paid extra tuition to take the accounting classes. And so the court would apply promissory estoppel. And she gets the $10,000. So quasi-contract is a legal fiction. It's not a real contract. It's intended to avoid unjust enrichment. Remember the house painter example. So if you see a house painter painting your house by mistake and you do not stop him, you hide out in your house and he finishes painting your house and then presents you with a bill, you're going to have to pay it, right? So again, here's promissory estoppel in more detail, and here's quasi-contract in more detail. So if I was speaking too fast on the former slide, you can slow down and take a look at these two. Article 2 of the Uniform Commercial Code. Woo, we've finished common law contracts. Applies to the sale of goods. That's it. Not real property, not services, not employment contracts, but goods. Remember that the defendant in a defective product suit may be the seller. It could be the manufacturer. It could be the manufacturer of a component part. And that if you have a contract that's both includes goods and services, which rules do you apply? The common law contract rules or Article 2? Remember the test. What is the dominant reason for the contract? form of a sales contract. Remember, contracts for the sale of goods costing $500 or more must be in writing to be enforceable. There is an exception to the rule, and that is specially manufactured goods not suitable for resale in the ordinary course of business. That was the Flowers Baking Company case. So Flowers Baking Company had agreed to buy cellophane wrappers from RP Packaging, and it was almost $14,000 worth of cellophane wrappers. They didn't have a written contract. The wrappers were made pursuant to the specifications that Flowers gave RP Packaging. When the wrappers arrived, they didn't fit the cookie tray. And so Flowers Baking Company said, oh, too bad, RP Packaging. This is a violation of the statute of frauds. We're not going to pay you for the cellophane wrappers. But remember what happened. The court in Virginia made Flowers Baking Company pay for the cellophane wrappers. They applied the specially manufactured goods exception under Article 2 of the Uniform Commercial Code. Risk of loss. So who bears the risk of loss if goods are destroyed? So in a sale on approval, remember the risk of loss remains with the seller until the expiration of the approval period or until the buyer accepts the goods, whichever happens later. This was the Pruitt versus numismatic funding case. Remember, Mr. Pruitt had been sent coins from numismatic funding worth, I believe it was, they were worth $60,000. And he received the coins, and prior to the expiration of the approval period, Mr. Pruitt sent the coins back to numismatic funding, and they never arrived. Who bears the risk of loss? Numismatic funding. Express warranties. An express warranty includes a statement of fact. It can also arise through a description of goods. So here was the example we went over in class. You buy a ring, and it's marked 14 karat gold. You wear the ring for a couple of weeks. It turns your finger green because it's not 14 karat gold. Has the seller breached a warranty to you? And the answer is yes. It's an express warranty. The description of goods. So if I give you an example on the exam that has a description of goods, and the goods don't live up to that description, then that's a breach of an express warranty. The implied warranty of merchantability is automatically made by a merchant seller selling goods that he or she ordinarily sells. Basically what you're saying with this warranty is that the goods are good for the ordinary purpose for which it is used. It may be disclaimed using either a disclaimer in as is, the goods are sold as is, or with all faults. It may also be disclaimed by using the word merchantability. There is no implied warranty of merchantability. You have to disclaim it in one of these three ways. Again, this warranty is often applied to the sale of food or drink. Some miscellaneous concepts. With sales at auction sales, know the difference between an auction with reserve and without reserve. Remember, if goods are sold at an auction without reserve, they must be sold to the highest bidder. An output or requirements contract is an exception to the rule that quantity must always be specified in a contract for the sale of goods. Remember, that's one of the things that must be in a contract for the sale of goods is quantity, with, of course, an output or requirements contract being an exception to the rule. Some remedies. What if there's been a breach of contract? One remedy is called cover. So if a seller is in breach of contract, the buyer may procure the same or similar goods from another source. We call that cover. And then sue for the difference in price. Another remedy that's available to both the buyer and the seller is the right to make a written demand for assurances. If assurances, so let's say you don't think that the seller is going to be able to send the goods in time. Or you're the seller and you don't think the buyer is going to have the financial wherewithal to pay for the goods. If the other party is given a written demand for assurances and does not respond within 30 days, the contract may be treated as repudiated or broken. And then finally, guaranteed to be on the final exam is specific performance. This remedy is where the other person is forced to go through with their contract. It is not always available. and it will only be granted if the contract involves something that's considered to be unique. You know that land contracts are always unique. Unique goods could be an antique, artwork, or something perhaps of special sentimental value. Then we talked about forms of business organizations, and so here's some key things for you to remember. That a sole proprietorship is a creature of common law, and the biggest disadvantage is unlimited personal liability. A partnership is where you have two or more people as co-owners. This too is a creature of common law, which means you don't have to file anything with anyone to create a partnership. Written partnership agreement is not required, and unless otherwise agreed, partners split profits equally. And note, the sharing of gross receipts is not evidence of a partnership. And then a regular C Corp provides the corporate shield from personal liability, and you need to remember that. Employment law. So a couple of key things to remember about employment law is that if you're an employee at will, your employment contract has no set duration, and you may be fired for any reason or no reason at all, as long as the discharge is not a violation of a law or an established public policy. So let's say you come into my place of business, and this is post-spring break, and you've decided that you're going to have so many facial piercings that everything that I can see is pierced. Eyebrows, lip, nose, multiple piercings in your ear. Can I fire you because of your piercings? And the answer is, yeah, I can. The Equal Employment Opportunity Commission is the federal agency that administers equal employment laws, and you need to remember that. Title VII seeks to eliminate employer and union practices that discriminate against employees and job applicants on the basis of race, color, religion, sex, or national origin. Remember, there are two theories of discrimination, and they are disparate treatment and disparate impact. Disparate treatment, I will ask you about, and you have to identify that. And disparate treatment is where an employer treats some individuals less favorably than others on the basis of race, color, religion, sex, or national origin. So remember that disparate treatment sometimes is difficult to prove because you have to prove motive. A bona fide occupational qualification is never, ever available for race or color, not ever. But here's my question, and the one that will appear on the exam. Is it a bona fide occupational qualification for an airline to only hire female flight attendants? And the answer, of course, is no. Sexual harassment, quid pro quo sexual harassment means this for that, and it's where supervisors seek sexual favors in return for job benefits, and that's clearly against the law. The Americans with Disabilities Act and Employment. The ADA is intended to provide employment opportunities to individuals with disabilities, and employers are required to have reasonable accommodations. So it applies to private employers who have at least 15 or more employees. It also applies to places of public accommodation and transportation and telecommunications. But this is what I'll ask you on the test. When does it apply to private employers? We talked a little bit about agency, and so this test has several questions regarding agency. A person acting under a power of attorney is called an attorney in fact. Under respondeat superior, an employer is liable for the negligent torts of an employee if they're committed within the scope of the employment. In other words, while the employee is working. An employer is only liable for intentional torts of an employee if they're committed not only while the employee is at work, but the intentional torts must also further the employer's business. And for that reason, it's very difficult to hold an employer liable for the intentional torts of an employee. A person is always liable for their own acts, always. And Moritz versus Pines Hotel There'll be a question on the exam based in part on the Moritz versus Pines Hotel case. And so in that case, an employee for the Pines Hotel was walking through the lobby with a vacuum cleaner and negligently, not intentionally, but negligently tripped, fell, and dropped the vacuum cleaner on a guest who is sitting on a sofa. It injures her knee. She is so angry that she starts yelling at Mr. Brown, the employee, and then he balls up his fist and pounds her in the head and gives her a concussion. That's the intentional tort. So Mrs. Moritz sues the Pines Hotel. What is the Pines Hotel liable for? And in this case, only the injuries to Mrs. Moritz's knee. The intentional torts did not further their business. Is Mr. Brown liable for her knee injuries and her head injuries? And the answer is yes. You're always liable for what you do. And then we talked a little bit about intellectual property laws. Patent laws are exclusively federal. There are no state patent laws. For something to be patentable, it must be useful and non-obvious. It does not have to be mechanical to be patented. A patent in the United States lasts for 20 years. Copyright. Copyright of an individual lasts for the life of the creator plus 70 years. Registration is permissive, not mandatory. And remember the fair use doctrine. So if there's certain circumstances where you can use copyrighted material without the permission of the copyright holder, and the fair use doctrine says that if copyrighted material is used in connection with a satire or a parody or for certain limited educational purposes or in quotation, it's okay. Remember the Two Live Crew case? I will question you about this one. So Two Live Crew did not violate copyright law when they made a parody of the Pretty Woman song. Remember their parody was I believe it was called Big Hairy Woman. Trademarks and service marks are registered with the United States Trademark and Patent Office. They may last forever unless they become generic. So Zipper is one of the famous trademarks that has become generic. And then you need to remember the definition of a franchise is an arrangement in which the owner of a trade name, trademark, or copyright licenses others under specified conditions to use the trade name, trademark, or copyright in purveying goods or services. Commercial paper, on to commercial law. So types of negotiable instruments. Remember there are two types, drafts and promissory notes. Remember that a check is a special type of a draft always drawn on a bank. It's okay for a check to say pay to and still be negotiable. A certificate of deposit is a type of a promissory note. Requirements of negotiability, you have to have a writing in some permanent movable form containing an unconditional promise if it's a promissory note or an unconditional order to pay a sum certain in cash. Cash means cash. A check may say pay to and still be negotiable. Is payment in foreign currency acceptable? Yes. How about payment in U.S. savings bonds? No, it would not be a negotiable instrument. Know the difference between order paper and bearer paper. So negotiation is simply the legal term for transfer. Order paper is payable to a specific person. It is negotiated by endorsement plus delivery. Bearer paper is created when an instrument is payable to cash, or perhaps the last endorsement is an endorsement in blank. And bearer paper is negotiated by mere delivery. And remember, what if there's a mistake? What if the payee's name is misspelled? The words are different than the numbers. Misspelling does not affect negotiability. The check is still negotiable, and the check is good for the amount written out in words, not numbers, if there's a discrepancy. Endorsements, remember endorsement in blank, you just sign your name. For deposit only is a restrictive endorsement, and remember that a written stop payment order lasts for 6 months. Forgery, assume someone comes in your dorm room and they steal a check and they forge your signature. They cash the check down at the local bank. You notify the bank immediately once you realize that this has happened. What's your liability? And it is 0. Secured transaction. We broke this down into 2 big steps, attachment and perfection. You have to know the elements of attachment. They are security agreement, value given, and debtor has rights in the collateral. Note, a financing statement is not part of attachment. Perfection. A perfected security interest is what the secured creditor really wants. And it can happen in several different ways. So if the creditor retains possession of the collateral, they have a perfected security interest. Or if a financing statement is filed, there's a perfected security interest. There may also be a question that asks you to know this. The purpose of a financing statement is to alert third parties of the existence of a security interest. In other words, it puts the world on notice that the creditor has a security interest. Consumer goods, remember there's automatic perfection of a consumer good as soon as it's sold to the first consumer. However, that perfected security interest can be lost when the first consumer sells to another consumer. And then note the purpose of a financing statement, remember that, is to alert third persons of the existence of the perfected security interest. Bankruptcy. We talked mostly about Chapter 7 or liquidation. We also looked at involuntary bankruptcy and voluntary bankruptcy and Chapter 13 extended time payment plan. Remember that a Chapter 13 plan is only available to a debtor who has a regular income. Involuntary bankruptcy is begun by the creditors of the debtor. If there are 12 or more creditors, at least 3 have to sign the petition. And remember, you may not force a farmer or someone who owes less than $15,775 or a charitable organization into bankruptcy. A discharge in bankruptcy is going to release you from almost all debts, including debts that are based on breach of contract and negligence. There are certain debts that are not dischargeable in bankruptcy, and so you'll have to be able to identify those. So if you don't tell the bankruptcy court of a debt, it's considered to be an unscheduled debt, and it's not dischargeable. Alimony and child support, not dischargeable in bankruptcy. Debts based on fraud or embezzlement, not dischargeable. And debts based on intentional injuries to people or property, not dischargeable. Almost all education loans are not dischargeable unless you can prove undue hardship, and that's very difficult to do. And any judgment based on driving under the influence or operating any sort of mechanical vehicle under the influence of drugs or alcohol, not dischargeable in bankruptcy. A discharge in bankruptcy may be denied if a debtor refuses to obey a lawful order of the court. So the Bankruptcy Abuse Prevention and Consumer Protection Act made some changes, and here they are, and you have to know them. Before declaring bankruptcy, you must take a credit counseling course. And you can only declare bankruptcy now once every 8 years, and the homestead exemption is very limited. It's limited to $125,000, and to even claim this much, you have to be a resident in that state for 720 days. Crimes. A crime is a violation of a public duty. It's prosecuted by the state. You have to know the burden of proof for a crime is beyond a reasonable doubt. The Constitution and crimes. The Fifth Amendment double jeopardy says you can't be tried twice for the same crime based on the same set of facts. How about this, though? Can you be tried for a crime and be found not guilty and then be sued civilly? And the answer is yes. That's what happened to O.J. Simpson, right? He was tried for the murder of his wife and found not guilty. Then Nicole Brown Simpson's parents sued him in tort for wrongful death, and he had to pay a money judgment to the parents. Be able to identify the following crimes. Shoplifting, of course, that's a statutory form of larceny. You don't have to leave the store to be found guilty of shoplifting. Be able to identify robbery, bribery, forgery, embezzlement, and conspiracy. And remember, with conspiracy, the crime is the agreement to commit a crime, and withdrawal is not a defense. Torts. A tort is a civil claim. The plaintiff is generally suing for money damages or for an injunction. The burden of proof in a tort case is much lower than a criminal case. It's simply a preponderance of the evidence, and you need to remember that. Defenses to negligence. You either live in a comparative negligence state or a contributory negligence state. By far, the vast majority of states are comparative negligence jurisdictions. And if you live in one of those states, there's a proportional reduction in damages based on the plaintiff's negligence. If you live in a contributory negligence state, then if the plaintiff is negligent at all, it may act as a bar to the plaintiff's recovery. Intentional torts we talked about, assault and battery. You could have assault, and remember these are the torts, these are not the crimes, the torts. You could have assault without battery, you could have battery without assault. You could have them together. Assault is simply the reasonable apprehension of bodily harm. Battery is an unwanted touching. Another intentional tort we talked about was the intentional infliction of emotional distress. We looked at the Howard Stern case, and how this was intentional infliction of emotional distress when he played with the cremated remains of a former guest on his show. False imprisonment is the intentional detaining of a person without consent. It doesn't mean detention in jail. Usually it's detention in the store. Most states do have a shopkeeper, also known as a merchant's privilege, to stop a suspected shoplifter, but the investigation has to be reasonable, both in terms of scope and time. Defamation, libel is written statements, slander, spoken statements that harm someone's reputation. Remember this, truth is an absolute defense. And then in terms of torts, remember that with ultra-hazardous activities, there is absolute liability for engaging in an ultra-hazardous activity. Gifts. Know the elements of the gift. I bolded it here. Please remember these. Donative intent, delivery, acceptance. There's one question on the final that requires you to remember that a gift causa mortis is revoked if the donor does not die, the donee dies before the donor, or the donor expressly revokes the gift. There also is one question about the Uniform Transfers to Minors Act, also known as the Uniform Gifts to Minors Act. And this is where a custodial account is created for a minor. These accounts are irrevocable. And can a custodian withdraw money from an account to take a vacation? And the answer is no. And then with personal property, we talked about lost, misplaced, and abandoned property. Remember, lost property, the rule generally is finders keepers unless you know the identity of the true owner. If you do, or you can reasonably ascertain the identity of the true owner, you need to return lost property to the true owner. Misplaced property is where property has been intentionally placed somewhere, and you know this because of the place where it is found. And then in that instance, of course, you need to give the misplaced property to the proprietor of the building to be held for true owner. Or you could return it to true owner, either one. Abandoned property, the first person who exercises dominion and control over abandoned property owns it. So you find this old dresser abandoned at the dump, and you take it home and you refinish it, it's yours. And then bailments, a bailment is a transfer of personal property. No transfer of title, simply transfer of possession. You have to know the three elements of a bailment: possession, consent, and knowledge. Be familiar with the Ziva jewelry case. Remember, this is where the Ziva jewelry salesman had $851,000 worth of jewelry in the trunk of his car before he surrendered his keys to the car wash attendant, and his car went through the car wash tunnel. As it was coming out of the other end of the car wash tunnel, a thief jumped into the car, stole it, and stole $851,000 worth of jewelry. So the question, later the car was found, the jewelry was not there. So the question is, was a bailment created with respect to the car? Yes. How about the jewelry that was in the trunk of the car? No. The car wash had no knowledge that the jewelry was there, and there was no consent for creating a bailment. They are not responsible for the loss of the jewelry. And that's it. So good luck on all of your final exams, and that's it for your final exam review. Good luck.